Hello, everyone, and welcome to Technology Tuesday, hosted by Out of the Box Technology. My name is Jennifer, and I will be your moderator today. Should you have any questions as we're going through the presentation, please go ahead and send those over to me using the question function on your GoToWebinar control panel. A little bit about Out of the Box Technology. We are a full team of QuickBooks experts providing training, integration, hosting, and support surrounding all versions of QuickBooks. We also have a team of bookkeepers that provide ongoing recurring bookkeeping services, as well as a development team that does website design, custom app development, and data migrations. Today, I'm very excited to welcome the folks from ADP to discuss common human resources myths and misconceptions. And on the line today, we have Kristen and Meryl, who are going to really dive into this topic. So again, if you have any questions as they're going through the material, go ahead and send those over to me, and we'll be sure to address your questions at the end. Today's session is eligible for continuing professional education credit. Ahead of that, here are our learning objectives for today's session as Kristen and Meryl go through the content. This session will be worth 1 CPE credit, and if you participate in all of our polling questions throughout the session, you'll receive a certificate after the session has completed. The session is being recorded, so if you wanted to dive back in later today or watch on demand on your own time, you can do that. You'll receive an email later this afternoon with a link to the recording. So with all of those housekeeping items taken care of, at this point, I'm going to hand things over to our esteemed presenters. Kristen and Meryl, I'll let you take it away.
Thanks so much, Jennifer. Okay, I think we have control.
Yeah, looks great. Absolutely.
Okay, perfect. So welcome, everybody. Thanks for joining us today. We have a few more housekeeping items to run through as we get started, but we're here to talk about common HR myths and misconceptions. So this is our disclaimer that we wanted to share with you all, just to let you know that what we're talking about today is truly like a high-level overview and a lot of really good practical information about the subject matter that we're covering. We provide it with the understanding that neither the writers nor we, the presenters, are rendering any sort of legal advice or any other professional service. So just make sure you're keeping up with the laws that apply to your business. And I think that's it for our housekeeping. So what we're going to talk about today, you'll see the agenda up on your screen. We're going to look at several common myths and misconceptions that small business owners may have with their workforce. We're going to focus on exempt versus non-exempt classifications. We're going to look at independent contractor versus employee classifications. We'll take a look at some interview questions, probationary periods, and other hiring considerations that have some myths and misconceptions surrounding them. And then we'll sort of circle out the employee life cycle. We'll talk about final pay. We'll talk about what it means to be at will, and get into some other termination considerations and some myths and misconceptions that surround those topics as well. So that's our agenda. And with that, I'm going to turn it over to Kristen to start us off on the first topic.
Great, thank you, Meryl, and welcome everyone. We're so excited you can join us for today. So I want to start by talking about exempt versus non-exempt classifications. That's often a point of confusion for the clients that we work with. But in order to do that, I first want to provide some context by talking about the Federal Fair Labor Standards Act, or as we refer to it, the FLSA. So as most of you probably know, the FLSA is the primary federal law that governs pay, and nearly all employers and employees are covered by it. So we deal a lot with small business clients, for example, those clients with less than 50 or so employees. And more often than not, they too are subject to the FLSA requirements. So under the FLSA, employees are classified as either exempt or non-exempt from the law's minimum wage and overtime rules. So while most employees are non-exempt, there are certain exemptions that are available under the FLSA. So you can take a look at the Department of Labor's fact sheet number 17A. I included a link at the bottom of this slide here, and that gives you a complete list of the criteria for all of these exemptions. So there are three main tests that employees must meet in order to qualify as an exempt employee. First, currently the employee must be paid a salary of at least $455 per week. But this is actually, it's really timely that we're having this conversation now and that we're doing this presentation. As many of you or some of you may know, the Department of Labor recently published a final overtime rule where this minimum salary that you see on the screen is going to increase from $455 a week to $684 per week for the administrative, executive, and professional employee exemptions, and that's going to take effect this January. So in order to be exempt come this January, in addition to some of the other criteria, those employees must be paid at least $684 a week. So in addition to that minimum, those employees to be exempt must be paid a fixed amount each week, regardless of the quality of work or the number of hours that they work. And then finally, the employee's primary job duties must involve specific responsibility, and those duties will vary for each exemption. And again, if you just take a look at that fact sheet that we provided, that would list out all of the different job duties that are required for each exemption. I also just want to pause here to talk about state laws. So we have certain states such as New York and California, and they have their own set of tests for employee exempt status, and those are typically harder to satisfy because, for example, it may include a higher salary threshold. So if you have employees who work in one of these states, you need to be mindful of those state requirements, and then if you're looking to get the exemption at both the federal and state level, then you have to make sure that your employee satisfies both sets of criteria. So if the employee satisfies the federal test but not the state test, which is often the case because usually the minimum threshold at the federal level is lower, the employee is going to be entitled to overtime in all circumstances that are covered at the state law. So I want to pause for our first poll, and we can see how the FLSA might affect a part-time employee. So you have Brittany. She works as a part-time accountant. She meets the job duties test to be classified as exempt. Because she's part-time, her employer pays her a prorated salary of $425 a week and classifies her as exempt. So the question is Brittany classified properly? And the options are yes, since she's part-time, she can receive less than the FLSA minimum of $455 a week. No, because she's part-time, she cannot be exempt. No, because she does not meet the FLSA minimum of $455 a week. So three different options. I think, Jennifer, you were going to be doing controlling the polling over there. So hopefully the participants can select one of those three options, and we'll pause for a minute and then report back on the results.
Yeah, absolutely. I've got that running, and I'll give everyone just a couple more seconds here to answer the poll question. All right, looks like the majority of people have voted, so I'm going to go ahead and close it and share what the results are. Can you see that, how people have voted?
No, I can't, but I know the answer.
All right, so it looks like 75% of those who answered the poll said no because she doesn't meet the FLSA minimum of $455 a week.
Perfect. And that was what we were going to say. So it looks like, yeah, so everybody, you know, pretty well versed on the FLSA requirements. So yeah, part-time employees can be classified as exempt as long as they meet the applicable exemption tests, and there's no, you know, prorating of salary, you know, in these circumstances. So they're still going to have to meet that, employers are still going to have to meet that $455 minimum, again, which is subject to increase come January of 2020. So with all of that, let's get into our first myth, which is that all salaried employees are exempt. And this is something that I've been hearing, throughout my career as an attorney, as outside counsel as well as in-house. And it's really, I think the basis for the belief is that, as long as an employer has an employee who's paid a salary rather than an hourly rate, then that person is going to automatically be an exempt employee. But as we've talked about, that's not necessarily the case. So I think the first thing we want to make sure, we impart to managers is that the words salaried and exempt are not interchangeable, especially in terms of talking about the FLSA and employment law. And just because you have an employee who's paid on a salary basis doesn't automatically mean they're exempt, because they still have to meet a certain threshold, right? That $455 a week threshold, and they have to still perform those duties in order to qualify it for the exemption. So generally, you have very few employees that meet this criteria. And we often tell clients that in those circumstances, if you have an employee who's a little cuspy or you're not sure about how to classify them, it's always best to err on the side of caution and try to classify them as non-exempt unless you're confident that they're performing the duties that qualify them for that exemption. One thing that we do tell our clients, though, is that you can pay a non-exempt employee a fixed salary. So we generally refer to those employees as salaried non-exempt, and they would get, the same as, generally for an exempt employee, they would get a standard salary each week. You just have to make sure in these circumstances that those employees are getting pay that's at least the minimum wage per hour, and that those salaried employees are also getting overtime pay when it's due. One other thing, unlike exempt employees, deductions from a non-exempt employee's salary are generally permissible as long as the deduction doesn't reduce that employee's pay below that minimum wage rate and that the employee is still receiving overtime. So a little bit different, in terms of when you're thinking about deductions for exempt employees, where they're very limited circumstances when you can deduct from an exempt employee's pay and still maintain that exemption. So if you have a non-exempt employee that you plan to pay on a salary basis, just remember that you're going to need to pay them overtime when it's due. So you want to determine their regular rate of pay, which you would do by dividing their salary by the number of hours the salary is intended to compensate. Here on the slide, we have an example of 40 hours a week. Some states do limit that number to 40 hours a week, so you just want to make sure that your state law is compliant. You also want to keep in mind that certain other types of compensation, such as non-discretionary bonuses, are included when you're determining that regular rate of pay, which you're using as the multiplier for that time and a half to determine the overtime rate. So we have an example on this screen where you have an employer who pays a non-exempt employee a weekly salary of $440, which is intended to cover a 40-hour work week. 1 week, that employee works 45 hours, so they're entitled to 5 hours of overtime. So here the regular rate of pay is calculated by dividing that $440 salary by 40 hours, and then you get a regular rate of $11 per hour. And then to calculate overtime, you want to multiply the 5 hours of overtime by 1.5 times the regular rate, which results in $82.50 of overtime pay that would be due to that employee. So that brings us to our second myth, which is on overtime. Specifically, this myth is that overtime is only due when an employer authorizes it in advance or when an employee hasn't waived their right to it. So a couple of problems with that myth. Under the FLSA, overtime must be paid whenever an employee works more than 40 hours a week, which I think we've talked about already, or in a work week. And that's regardless really of whether it's authorized in advance. You can certainly, as an employer, as a manager, you can certainly have a policy that requires your employees to obtain written permission, and we generally advise that as a best practice for employees working overtime. But if you have an employee who is violating the policy and working overtime without authorization or without permission, they're still entitled to that pay, and you can't withhold it. Otherwise, you're going to be flying in the face of the FLSA requirements. That doesn't mean it's like a free-for-all for employees, and the employer can certainly discipline employees, issuing them written discipline, oral, etc., even up to termination if you have, those who are frequently violating the policy. But under no circumstances could you use, withholding their pay as a form of discipline. And just to touch on that second point in the myth, employees cannot waive their right to overtime, even if they're willing to do that on a voluntary basis. So just before I wrap up this section and turn it over to Meryl, there's a couple of other problematic practices that we see with respect to overtime. I just want to highlight a couple of them. A lot of employers mistakenly believe that they can give employees 1.5 hours of paid time off for overtime work instead of paying them overtime, and this is something that's usually referred to as comp time. That practice is prohibited in the private sector, and even if an employee tells you that they would prefer to have the time off instead of the overtime pay, or they voluntarily agree to it, or they promise they're not going to sue you, it's still not okay. You cannot replace the compensation with time off. Also remember that overtime must be calculated on a per work week basis, subject to some exceptions, of course. Employers are prohibited from averaging hours over 2 or more work weeks. So if you have an employee, for example, that works 50 hours one week and then 30 hours the next work week, you can't add them together and decide that they don't need overtime. They would still be entitled to 10 hours of overtime for that first work week. And then finally, some employees may tell you that they don't mind working off the clock, or that they, prefer to check their email from home, or before they come into work and punch in. Non-exempt employees are not permitted to work off the clock, and that's also a problem. Even if they tell you that they don't mind, they would still be entitled to pay for that work that they're performed. And again, if they're habitual offenders, you can make sure that you discipline them appropriately, but don't withhold their pay. So finally, a couple of best practices that we have here on the screen before I turn it over to Meryl. You want to make sure that you're paying all of your non-exempt employees in accordance with federal, state, and local law. Misclassification is one of the most common FLSA violations out there, and it's also something that is really at the focal point of government, federal, and state enforcement. So it's really important that you make sure that you're classifying your employees correct as exempt or non-exempt. We think it's a great idea, especially now with the new DOL overtime rule that's going to take effect in January. It's a great idea to audit your exempt positions. So what I mean here is just make sure you're looking at your exempt employees and ensuring that they're still continuing to perform those job duties that qualified them for the exemption in the first place. Sometimes job duties change, as you know, so you just want to make sure that it's still current and consistent with the rules. Another point I think I wanted to make to that end is, another myth that I probably should have thrown in here that I didn't is oftentimes people think that the job title itself, will or will not qualify an employee for an exemption, but it's really not the title. It's really about the work that they're performing. If you have an employee who, after you review, you realize that they may have been misclassified as exempt, obviously that might be a great time to consult with legal counsel to figure out the best approach to address the misclassification. It may require some some back wages owed if they were working over 40 hours a week, when reclassification. And then, again, keeping in mind the DLL rules, if you do decide to reclassify an employee, sometimes it's a tough conversation, especially when you have an employee that's going from exempt to non-exempt. They may feel like it's, a demotion. They may like the fact of being an exempt employee. They have a certain level of flexibility. So just make sure that you're proactively communicating to them and explaining the basis for your decision. And even some of the benefits of being reclassified as non-exempt, that an employee is entitled to overtime and things of that nature that they didn't enjoy as a salaried exempt employee. So with all that, I'm going to turn things back over to Meryl to get into our next section.
Great, thank you. I'll give you a break. That was a lot of information. So we want to turn now and talk about another hot topic that we're seeing a lot of changes at the state level predominantly, and that's talking about independent contractors and making sure that you're properly classifying your workforce, whether they are an independent contractor or whether they should be considered an employee. And I think a lot of what we're seeing, comes along with the rising popularity of the gig economy, and this sort of change in employee relationship, how you are interacting with your workforce, with the flexibility, and we think of Uber drivers and the like. It's causing us to rethink how we define what truly is an employee and what truly is an independent contractor. So while the situations are sort of evolving, the law's been pretty consistent, at the federal level for a while, and there are tests that you have to go through and hurdles you need to make, to meet to make sure that your workers are properly classified. There's the allure for some employers in classifying workers as independent contractors comes from the fact that those workers wouldn't be entitled to minimum wage or overtime and certain benefits. But the reality is very few of these workers will qualify as independent contractors, so you need to be careful. So what is an independent contractor? So typically the definition is they're workers who are free from supervision, direction, and control. Typically they're self-employed, they carry their own insurance, invest in their own facilities, use their own equipment and supplies, pay for their own expenses. They assume the risk of profit and loss, and oftentimes simultaneously offer their services to other businesses, and that's a big factor. But when you look at it from a high level, as a rule of thumb, the more control that your business has over a worker, the more likely that worker is going to be considered an employee of your business. So with that overview, we'll turn to myth number 3. If the worker signs a contract with an employer, then they're definitely considered an independent contractor. So does that contract signing automatically impact the classification? So while that is one factor, it's not the only factor. So a worker is presumed to be an employee unless they meet the requirements under whatever state test may apply to your business, if there is one, and then under the federal test for certain. So simply having the contract in place is not going to guarantee that the worker is an independent contractor, though it will be a factor in your analysis. So there are a number of tests that are used to evaluate a worker's status. The most common is the IRS's common law test you may have heard of, maybe using it. In addition to that, the Department of Labor, the EEOC, and then several states as well have their own independent contractor tests. So you may have heard, if you're doing business in California, that they just recently passed a law expanding the use of the ABC test, which is a very restrictive test when determining whether a worker is an independent contractor or an employee. And that new law is, is going to impact a lot, the Uber driver industry in gig economy. So something to keep on top of if you're having, if you have work that you're doing in California. So, and as you apply these tests, this is an overarching, rule, like consult legal counsel if you're not sure. If you have specific questions, the penalties for misclassification can be severe, and you just want to make sure that you're properly classifying your workers. So here's the IRS common law test, which is the most common one, hence the name, but also the most common. And the three factors that are typically looked at when you're assessing a worker are the different levels of control. So the first being behavioral control, and you look at how much instruction is given to the worker and factors to consider: how much instruction, whose equipment is used, is the performance evaluated, is training provided. All of those types of questions go into evaluating behavioral control. And then financial control is another piece, an important piece, looking at how the worker is paid. Does the worker make investments in their tools and facilities? Do they have unreimbursed business expenses? All of those types of factors go into financial control. And then lastly, looking at the type of relationship, and this is where the contract question comes into play as a factor, to see if there is a written contract, to see whether the worker's services are available to other businesses. Is the worker entitled to employee benefits? Looking at the length of a relationship you have with the worker, whether the services that are provided are a key aspect to the business. So all of these factors need to get weighed. No one factor is going to stand alone when you're applying the common law test. So keep them in mind and document every assessment that you're doing so that you can have a record that you were properly applying the test and then reaching a conclusion that was based on the job and its duties. So let's take a look at this next scenario, and we can apply some of what we just talked about. So Cindy is hired to complete a 3-month project, and then she actually decides to remain with the company. She's a graphic designer. It was a specialized project. The project was for 3 months, but the company realized that there was a lot more for her to do after those 3 months. So here we are 8 months later. Cindy is still working at the company. She's being paid a set salary each week. She reports to the office daily. She's working from 9 to 5, using the company computers and attending staff meetings. So given all these factors, would you say that Cindy is, her current state, an independent contractor or an employee? So I'm going to turn the poll question back over to Jennifer to open the poll and perhaps give us the results after everybody's had a chance to weigh in, and then I could speak to it a bit more.
Absolutely. Yeah, I just launched the poll, so everyone can go ahead and pick what they think the correct answer is about Cindy. And we'll give that just a couple more seconds to see if what everyone thinks about Cindy's status as a contractor or an employee. All right, it looks like we have the majority of people are voting, and 91% say that using the IRS test, Cindy is not an independent contractor.
Awesome, great. Yes, thank you. You guys got it right. For all the reasons we talked about, the continuity, her reporting to work, using the computers, going to meetings. So this company is clearly exercising a lot of control over Cindy's work. So she, at this point, has crossed over independent contractor to an employee. So I'm getting a lot of feedback. I'm wondering if there's anybody that can put me on mute, perhaps. I'm hoping you guys aren't getting it as well. Okay, that's better. Thank you. So other things to look at: independent contractors often paid a flat fee or sometimes paid on a time and materials basis. And then just even the length of time that went into Cindy's extension of her work. And that also, importantly, that she's providing the type of services that are a key aspect to the company's business. So for all those factors, everyone, you guys were right in classifying her as an independent contractor. So let's take a look at myth number 4. Individuals who work from home and have some flexibility over their hours are considered independent contractors. So we'll bust the myth, again, because of the fact that it's not just one factor. Workers aren't considered independent contractors simply because they work off-site and have flexible work hours. And they suggest that the employer has less behavioral control over the worker, but again, doesn't automatically mean the worker is an independent contractor. So the employer is still going to need to go through and evaluate the other factors of the relationship and make sure that all the applicable tests are met before classifying the worker as an independent contractor. So we can wrap this section up, I think, with just a few best practices. It's important that you carefully evaluate all the federal and state duties tests, and when you're in doubt, just classify the worker as an employee, and seek legal counsel if you have questions and you need to conduct an audit. The reality is misclassification. If you're found to have misclassified, workers can deny them, rights and protections that they're entitled to. It reduces tax revenue that the government collects. So, for these reasons, the federal and state agencies have made misclassification a priority as far as enforcement. So you just want to err on the side of caution, make sure you're documenting your classifications and seeking out assistance if you need help ensuring how your workforce is classified. So with that, back to Kristen for our next topic.
All right, thank you, Meryl. So now we're going to go over some common myths associated with the hiring process. But as per usual, before we get into that, I just want to start with some context. So I want to review some of the non-discrimination laws and how those non-discrimination laws impact hiring and other employment decisions. So at the federal level, you have employees and applicants who are protected from discrimination and harassment on the basis of age, race, color, sex, national origin, basically everything that you see here on this screen. In some cases, these laws may extend to non-employees such as unpaid interns or volunteers. And then you get to the state and local level, which also have similar protections, but they often extend beyond just those characteristics that you see here on this screen. So some states protect employees on the basis of family status, crime victim status, sexual orientation, and gender identity. That has been, big. We've seen a lot of amendments to that effect just with, the focus on the LGBTQ. So you just want to be aware, certainly at the federal level, and then the laws at the state level as well, and understand those that may apply to your business. And keep those laws in mind through every step of the employment process, not just at the hiring phase. So with all that, our next myth is no question is off limits when you're evaluating whether job candidates are a good fit. And the fact is that certain questions certainly are prohibited by law, or not that they're prohibited by law, but certain questions may have the potential to cause a candidate to reveal a protected characteristic, so their age or marital status or disability, etc. So that's not unlawful per se to ask them, but the consequences or the risk that results from them disclosing that information could be a problem. So I thought instead of I thought it might be helpful to just go through some examples or some questions that may come up during the interview to give you some, some understanding of why these questions are problematic. So the first question is, how many sick days did you use last year? If you're asking an employee about, sick days because you're trying to gauge whether or not they're going to be able to show up, this question could cause them to reveal that they have perhaps a protected medical condition, and certain absences are protected by federal, state, or local laws. If you think about the Common Disability, Americans with Disabilities, or certain anti-discrimination laws based on disability at the state level, paid sick leave laws. So instead of asking an employee how many sick days that they used in the previous year, you might want to just explain that certainly regular attendance is necessary for the role, and explain what the days and hours requirements are. Another problem, we've been seeing a lot of this lately, but another question that you may want to refrain from asking is what the employee's current salary is. We have a number of jurisdictions, and this is certainly a big HR trend that we see in the employment law world, but certain jurisdictions such as California, Oregon, New York City, Others as well, they've passed laws that restrict employers from asking an applicant about their pay history during the hiring process. The basis for this legislation is that the belief that pay history may reflect past discriminatory pay practices of a previous employer. So you're just sort of perpetuating the cycle, and that could lead to lower wages in the new job if you're basing compensation on that, or in part on that employee's previous pay. That said, you can ask an employee and continue to ask an employee about their salary expectations, and obviously you can tell them what the range may be for the position in question. Another problematic question is, can you work Sundays? So you want to avoid these questions or questions like that, because that could cause an employee to provide information about their religious beliefs and practices. If you want to make sure that you have a candidate who can work on a Sunday, you might want to just explain the regular work schedule to them and ask whether they can work those hours. Just note that in some circumstances, you may be required to provide a reasonable accommodation for an employee's religious beliefs or their practices, and that at times could be allowing an employee to voluntarily swap shifts, for example, with a coworker, so that employee can attend religious services. So just be mindful of those accommodation requirements. A couple more questions that you want to avoid during the interview is if you have a candidate who has an accent, you don't want to ask them where their accent is from, as you know, that might cause them to reveal their national origin or their ethnicity, which are generally viewed as protected characteristics. If you're worried that a candidate may not have the authorization to work in the United States, you can certainly ask, and I'm sure you've seen this on applications, whether the candidate is authorized to work in the U.S. If you do this, just make sure you're asking this question of all candidates and not just certain candidates that you know, in this case, for example, if the candidate has an accent. Another question is, do you have or do you plan to have children? Obviously here, you know, there are laws that prohibit you or as an employer from discriminating against individuals because of pregnancy. You know, again, you can certainly explain the expectations related to, you know, work hours, overtime, if there's any travel involved, etc., and just, you know, limit your questions to focus on whether or not the applicant can meet those requirements. Last question before you move on is you don't want to ask a candidate whether or not they have a disability. You know, again, the Americans with Disabilities Act and other state laws will prohibit employers from asking these questions. There are certain limited circumstances where you can ask whether a qualified candidate would need an accommodation to perform essential job functions, you know, especially if there's something that's obvious during the interview process. So, you know, before you move on, I mean, I think the bottom line is you just want to make sure that you're avoiding questions that would indirectly or directly identify a candidate or cause a candidate to disclose a certain protected characteristic. If that comes up, you know, during the interview, which it often does, you know, interviews are very conversational. Sometimes when you're trying to sort of, you know, break the ice, you know, don't be alarmed. Just try to redirect the interview to go back to talking about the job in question. And obviously, if you decide you're not going to move forward with that candidate, just make sure that you have a justifiable business-related reason for not moving forward. So with all of that, we'll go to our next poll question. We have Erin. She is a hiring manager for a small landscaping company, and she needs to hire a bookkeeper and has decided to schedule in-person interviews. She's pretty chatty and typically likes to find out a lot about a person before she hires them. And the questions she'd like to ask, I hope we're able to show on your screen, some of which you'll find may have the potential to reveal protected information. So, you know, the thought here is to select which questions you think Erin should avoid. And as you probably are able to see, there are going to be more than one options of questions that are a bit of a problem from an employment law standpoint. And so we'll have Jennifer open the polls and then just report back on the results.
Absolutely. Yep, those are showing now, so everyone can go ahead and take a few seconds to select which of these questions Erin should avoid. And I think everyone will hopefully pick the right answers, as we've gone through some really great examples. And looks like so far everyone is selecting that Erin should avoid the question of, do you have kids? And we looked at the age. What year did you graduate high school? And I see a ring on your finger. How long have you been married? Those are the three that everyone seems to be selecting.
Yep, I would say that's about right. You know, I mean, obviously all of these are giving candidates the potential to reveal their protected information. I'd also add to that list, that's an interesting accent. Where are you from? That's another one that we want to avoid. And again, these aren't illegal per se, to ask that. It's just what can come from asking those questions that it just creates an unnecessary risk and headache for hiring managers. Okay, so this brings us to our sixth myth for today about the hiring process, and that is that all new hires should complete a probationary period. And I know a lot of our clients, they like to use them. They continue to use probationary or introductory periods to assess a new hire's performance. But the problem with that from an employment law standpoint is that this sometimes creates confusion regarding the employee's at-will status. So when you hire an employee at will, the argument there is, you can, or the employee can terminate the relationship at any time for any reason, as long as it's a lawful reason. So we'll talk about that a little bit later. But when you have employers who are using probationary periods, employees sometimes think mistakenly that once they complete that 60 or 90 days, then they're good. They're no longer at risk for termination based on their performance. They're only going to be let go for good cause. So if you ultimately end up letting that person go after their quote unquote probationary period, you'll see, perhaps a risk for the employees to file wrongful termination complaints, and then putting the legal issue aside, it also creates a sort of a negative connotation for employees who believe, that they're already being placed on some kind of probation or disciplinary program right at the start of their employment. So even from that perspective, it's really not a best practice. What we advise, instead of calling anything a probationary period or introductory period, just use that time to work with your new hire, make sure you're meeting with them regularly, make sure that they have, their expectations of their role are made clear to them, that they have the tools to meet these expectations, that there's an open door policy. If they have questions, they know to come to you. But you want to, for the reasons that we just talked about, consider avoiding those formal probationary periods. So a couple of best practices before I turn it back over to Meryl. Certainly we've talked about interviewing employees can be very tricky, so you want to make sure that you're training your hiring managers on what they can and what they should not be asking to help you get the information that you need to make the right decision. Try as best you can to focus on the requirements of the role. I know it's not always easy because it's, you want to have a good rapport with the person and establish some kind of relationship there. So, if you do that, that's okay, but, make sure you're not really talking about anything that might open up, the possibility of talking about some of the issues that we discussed. Also, check your state law and your local law as well, and make sure that you're aware of any laws that pertain to salary history bans. And if you are in a jurisdiction that does not allow you to ask about an employee or candidate's salary history, make sure you're updating your application forms. It's not on your employment applications. If you're contracting out with a third-party vendor, make sure that they're aware of those requirements and those prohibitions. And then finally, as we just talked about with respect to the probationary periods, just make sure with your new hires that you're setting performance goals, that they're aware of their requirements, and that they have all of the resources that they need to be successful. So with that, I'm going to turn it back over to Meryl to talk about our final topic.
Awesome, thanks so much. So let's hit on the final topic for today, termination considerations, and talk about some myths that you may come across during the termination process. So myth number 7, at will means I can fire my employees anytime for any reason. So no, while at will generally means you can terminate an employee for any reason, if you're in an at-will state and there's no contract or other agreement that would change the status. The reason always and still needs to be a lawful one. We've talked about some of them already today, but there are a number of laws that prohibit employers from retaliating against individuals for exercising their rights under the law. So you can't terminate for a method of retaliation. Employees are also protected from discrimination based on certain characteristics, as Kristen touched on earlier, such as age and race and religion. If you try to terminate an employee because they engage in protected activity or because of a protected characteristic, then you'll be subject, in all likelihood, to a claim, perhaps regardless of the at-will status. And contracts, statutes, courts, public policy, there are exceptions. But as a best practice, if you have an employee that isn't necessarily performing well or is violating company policies, then you're better off handling the situation through disciplinary procedure, documenting the issue, addressing it as you would have other previous situations, and make sure that your terminations are not a surprise for your employee. Particularly if the reason is due to performance, there should be a lot leading up to actually making the termination. Myth number 8, if I need to, I can withhold an employee's final pay. So this is another common myth that gets thrown around in a lot of different scenarios. And employers may think that they can withhold final pay until an employee returns company equipment or company property, for example, but that's not the case. The fact is that employers have specific final pay deadlines, typically, and they have to meet them regardless of whether the employee is failing to return company property. Federal law requires that final pay be made at the next regularly scheduled payday, and then there are states also that have different pay requirements, some requiring final pay sooner, such as at the time of termination. So as a best practice, you want to make sure you're getting back any company equipment or property prior to the employee's last day, and hopefully then avoiding having to contemplate what to do to collect on what the employee owes you. So, and then while we're just touch on deductions from final pay, because it's always an area that we get a lot of questions about, and I think probably worth hitting on for a minute. So while you can't withhold a final paycheck, there are some reasons where you can make deductions under federal law. So if you were for non-exempt employees, the FLSA will allow deductions if there's lost or stolen or unreturned equipment, as long as those deductions aren't reducing the employee's pay below the minimum wage and deductions are not cutting into any overtime pay. But there are some states that will prohibit deductions entirely or have additional requirements. So again, always make sure you're checking the state law before you make a deduction. And then also keep in mind how your employee is classified, because you can't make these types of deductions for exempt employees. And then if you are going to make a deduction and it's permitted, there's rules of the road you should be following too. Always make sure you're getting the employee's consent before making a deduction, and a specific consent with particular terms, why the deduction is being made, whether it's for company uniform or equipment or theft, how much of the deduction, and then you're going to want to get that consent in writing. And I strongly also would urge consulting with legal counsel before you even go down that road, because again, this could lead to problems later on. So myth number 9, if my employee quits, there's no reason to get their resignation in writing. So regardless, even if it's a voluntary resignation, it really is a good idea for you as the employer to get the employee's resignation in writing, even though they may have notified you verbally that they're leaving. For a couple of reasons. Doesn't have to be a lengthy document, but if you can, you should get confirmation in writing. And an important reason, if the employee ever challenges the reason for their departure, you're going to want to have the voluntary resignation in writing. For example, if the employee were to try to seek unemployment benefits, or if they were to file a complaint against you, it'd be great to have the documentation showing that it was the employee's decision to leave the company. And just to keep in mind also, while most employees who quit are not going to be eligible for unemployment benefits, just the fact that the employee did quit doesn't always disqualify them to receive unemployment benefits. Employees who resign have to show that they quit. Typically the standard is for good cause. And while good cause by definition will vary by state, employees who quit as a result of retaliation, like we talked about earlier, or perhaps to care for a sick family member, or because there's been like a huge change in their schedule and there's been a significant reduction in hours or pay, they may also, those folks may be entitled to unemployment benefits. And so all of these eligibility rules vary by state, so make sure you're checking your state law for the details on unemployment. And that'll bring us to our final myth, myth number 10, exit interviews are a waste of time. And they're not. The fact is they can really help you identify the reasons your employees are resigning so that you can make the workplace a better place and hopefully avoid having another situation where an employee is leaving. As you start to see trends, you could address weaknesses. And also it's important, especially for your employees who remain, that you can, use these exit interviews to transfer knowledge to a successor or a replacement, so you're not leaving them in the lurch if one of your employees decides to resign. So a couple of exit interview best practices. If you can and you want to, help direct the conversation, provide the resigning employee with a questionnaire, and that way you can sort of lead the conversation. Review the questionnaire in person will give you the best option for getting details from the employee, and that way you could ask follow-up questions and explain why. It's going to help facilitate candor and hopefully an open dialogue. And you can also, reassure the employee that you'll keep their responses confidential to the extent that you can. And at this time, you may also find that you're going to need to look into an allegation of discrimination or harassment, or it could be some misconduct that was actually the cause of the employee's decision to leave. So if you're put on notice at that point, you can then begin to conduct a prompt investigation and consider what your next steps are going to be, so you're not blindsided with a complaint after the employee has walked out the door. So just to wrap up some best practices, I keep harping on documentation, but it really is so important to have thorough and proper documentation. It's important to make sure you understand final pay rules, get voluntary resignations in writing, conduct exit interviews with resigning employees, and you just, overall treat terminations carefully. Remember, if you are an at-will employer, then you can terminate for any lawful reason, with the exceptions of things, that may change the status, like a contract or an agreement. Have the documentation for the reason for termination and keep it in the employee's personnel file. And also consistency. I think one of the things we just always emphasize is make sure that you're treating terminations consistently, that if you've encountered a situation like this in the past, that you're thinking back to how you've handled it, so that there's a pattern and practice and a job-related reason for whatever decision you're going to make with regard to termination. So I think that's some of what I wanted to touch on today for myths and misconceptions. So I'm going to turn it back over to Chad, I think. he has a few words he'd like to share with you all. And, for Kristen and me, thank you for listening to our part of the presentation.
Yeah. Hello, everybody. Thanks again, Kristen and Meryl, for doing the presentation. That was great. Everybody, my name is Chad Rabideau. I'm the sales director that works directly with Out of the Box Technology. I'll connect with everybody via email just so you guys have my contact information. Just send a little bit of information on ADP and kind of what we do. But payroll is really about 10% of what we do at ADP. Really a human capital management solution. We help from everything from hire to retire and everything in between. We have a lot of integrations that we actually have built in with Out of the Box, such as integrations with T-Sheets to help with job costing, QuickBooks, R&D credits, just to name it some. We also have some great discounts that you have access to through Out of the Box. So if you guys are interested in getting some more information on ADP and a quote, please respond to my email and we'll set something up. And I'll pass this over to Jennifer, and she can follow up with a few slides that she has.
Excellent. Thank you, Chad, for just kind of bringing that full circle with our relationship here at Out of the Box Technology with you guys at ADP. And it was something that I learned as our partnership has kind of grown, is that I always thought ADP equaled payroll, but it's definitely so much more. And the insight that Kristen and Meryl have given today has been really, really great. I know that we've gotten a lot of good feedback just from the audience today, just saying, this was great. Thank you so much. Learned a lot. So ladies, thank you so much for all of your information. I know I just wanted to reiterate something that you said at the beginning. This isn't like strict legal advice. People shouldn't exactly take all of this, to the bank kind of thing, but I think it's definitely a lot of really good best practices and information. So thank you, ladies, very much. And Chad, thank you for joining us as well. I'm very happy to have you on the line. So I'm going to go ahead and take things back real quick just to wrap up today and talk about our upcoming Technology Tuesdays. It was so great to have ADP on today, and next week I'm excited. We'll have T-Sheets on. So I know Chad mentioned kind of the integrations of everything. So we'll have our friends at T-Sheets presenting next week, and then our Chief Technology Officer, Andrew Abrams, is going to be on with us October 29th talking about reasons to host with Out of the Box Technology. So if you're new to the hosting environment or not exactly sure what that means or if it's the right fit for you to host your QuickBooks with us here at Out of the Box Technology, definitely check that out. It's really kind of an interesting concept and just a really great way for us to help keep your data secure and all of that. So we hope you can join us. Again, these are all completely free and we do record them. So if there's an episode that you missed, you weren't able to join live, definitely check out our blog. We have all the videos there. Or if you are interested in some of these coming up but can't make it, again, just go ahead and register and you'll get a link directly to those recordings. Everyone who's on the line today, again, as I mentioned, will get a link to this recording as well. So if you kind of wanted to revisit anything, you can watch that back. And then as Chad mentioned, he'll be reaching out just so everyone has his contact information, no pressure, anything like that. But if it is something that you wanted to dive a little deeper with, you have access to Chad and he can help you out. So thank you for that. We appreciate it. If anyone does have any questions or interested in another topic for Technology Tuesdays, my information is now on the screen. You can reach out. We'd be happy to get something on the schedule that you're interested in. So let me know. Again, thank you everyone for joining us. Kristen, Meryl, Chad, appreciate your time today, and we hope to see everyone again soon.